Hello, my name is Mike McKinley with Elder Care Law of Kentucky, and this presentation is meant to instruct and inform any potential clients that might be interested in protecting their assets and still being able to control them once they're protected. Protected, of course, from the nursing home or creditors, any kind of long-term care costs that might come up in the future. But it's also meant for some of my current clients who, after the initial consultation, after they go home, they decide, you know what, I can't remember exactly why we're doing it and how it works and everything like that. This is a great reference. You can review this anytime. It gives a basic layout of what we're doing and why we're doing it. Of course, we're not using exact numbers or names because this is meant to be somewhat generic to apply to all of our clients, but it should be very helpful. And of course, we can always answer any specific questions if you have them after you've reviewed this video. So the ProActive LLC Asset Protection Plan, basic design and implementation. The purpose of the plan. In law school, we learn about property rights and how it's like a bundle of sticks. Well, the primary sticks that we're concerned with in doing this plan and protecting assets are title, access, and control. Title is whose name is the property in, who owns it. Access, of course, is being able to get use of the asset. If you live in if you own a house, can you live in it? Do you get to make all the decisions about the house? Money, when can you access the money? If you need it, once we protect it and you need it, later on you decide you need some of that money to spend for whatever reason, can you gain access to that money? And then, of course, control, who makes the investment decisions, who has to call the financial advisor to tell him to buy, sell, or trade, who decides what accounts the money's in, so on and so forth. Now, the foundational asset protection plan that we typically do with most of our clients involves removing title and control from the client in order to protect the asset. What does that mean, remove title and control? So you can think of creating an irrevocable trust. We put all of your property into the trust. Usually it's a son or a daughter who is your trustee. You get everything titled into the trust. You start your 5-year look back. And then along that 5-year period, if you ever need the money out or you want to change something, you have to call your trustee and have that person get the money out of the trust and give it back to you. So you can think of it like having a safe in your daughter or son's house. You put your money in the safe, and if you ever want the money back, you have to call your daughter or son and say, hey, I'm coming over, unlock the safe, I need to get my money back. It's a very good analogy of how the traditional plan works. For all these plans, assets must be protected for a minimum of 5 years before the client has to go to a nursing home in order to protect 100% of the assets. If you don't make the 5-year period, we can still protect a large portion of your assets. It's just if you want to protect 100% of them, you have to protect them within 5 years before you go to the nursing home. For most of our clients, this is perfectly acceptable. Children are usually the trustee. I already went over that. But occasionally we get a client that for whatever reason is not comfortable relinquishing control of their assets. That maybe they don't have children. Maybe maybe it's a husband and wife. They really don't have any children, and they're not comfortable asking their good friend or a niece or a nephew or a cousin to step in as a trustee to have to give them money back whenever they want it. Sometimes they have children, they just don't have any children that they trust. That can be an issue. Or sometimes they're just too young. They're like, Mike, we're only in our 60s. We're still shaking and moving. We don't want to have to call our child every time we need to do something. Or, I've had a client who he enjoyed day trading, and he was buying and selling and doing all that kind of stuff with his stock on a regular basis, and he didn't want to have to go through his daughter every time he wanted to do that. So for this particular type of client, we have a LLC add-on package that we add on to the plan. This allows the client to only have to give up title in order to protect the property. Control, the ability to make investment decisions and access to their money without having to consult the trustee is very important to some clients. It can sometimes be the difference between moving forward to protect assets and doing nothing. Other elder law attorneys are not doing this to my knowledge, and frankly, I'm not sharing this with them because this is part of what makes us unique and special for our clients. And I've had a lot of clients who have come to me because all the other elder law attorneys are telling them, either you give up control or we can't protect your money. Well, that's just not the case. As long as we can do it within 5 years before you go to a nursing home, we can accomplish this and still allow you to control your assets, as long as you're mentally competent and obviously as long as you're alive. So this is a pretty good visual example of how the plan is going to look. The client family irrevocable trust, that is the foundational trust document. That we're going to do that document for pretty much every client. It's just with some clients we add the client family LLC. It is a manager managed LLC, meaning even though you don't have title to the assets held by the LLC, you are the managers. We name you as managers, so you have complete control over everything that is owned by the LLC. And again, as long as you're mentally able to manage your own affairs, the trustee or your children or no one else can step in and remove that control from you. The types of assets that we would typically put in an LLC, pretty much all non-qualified funds and property. So IRAs, 401ks, we don't put those in trusts or in the LLC. They will stay outside. But everything else we want to put in that trust, or I'm sorry, into the LLC. The one thing we do want to put in the trust is your personal residence. And the reason we want to do that is so you don't lose your homestead exemption and have to pay a higher tax rate for your annual property taxes. It's also important to put property that might have a mortgage on it in the trust so that it doesn't trigger the due on sale clause. Otherwise, we would have to get special permission from the mortgage company if we try to put mortgage property into an LLC. Last thing we want is for one of our clients to have a mortgage, have the bank call their loan and make them refinance now that the interest rates are going sky high. And banks are always your best friend when the interest rates are going down, but when they're going up, they're far more likely to try and pull a shenanigan like that. The other thing the irrevocable trust will own is the LLC membership interest. When I say membership interest, it's the same as saying the stock, okay? It's the actual ownership of the LLC. Now, we'll let the clients maintain 1% ownership per person. There are tax reasons we do that, and it has to do with being able to make distributions to owners that are not in pro rata what their ownership percentage actually is. But that's kind of getting into the nuts and bolts of the actual documents and is pretty technical. As managers, clients can control and access all the assets held by the LLC until death or incompetence. Now, if you look at the client family irrevocable trust, look at the arrows. The client is going to be the settlor or the grantor. The two words mean the same thing. They define the rules of the trust. They define who the trustee is going to be, who the lifetime beneficiaries are, and who the death beneficiaries are. Trustee can be anyone except the client themselves. We have to have a third party act as trustee. That can be a bank, that can be my law firm, that can be your children, that can be your sister, your cousin, whoever, your best friend. Doesn't matter as long as they are trustworthy and reliable. That's really all that matters for the trustee. The lifetime beneficiary means who can get property out of that trust while the grantors are still living. Again, usually the children, but can be anyone. Then the death beneficiary. Who gets all the stuff when the clients have passed away, at the second death? So if I'm dealing with a married couple, nothing gets distributed, nothing changes until both spouses are deceased. Steps to complete the plan. The first thing we do is we submit all the we need you to submit all of the information to us for document drafting. That includes a completed questionnaire. We need dates of birth, addresses, etc. Make sure we can read the name spellings, particularly on your children. We need to know what you own. If you own something you haven't told us about, we cannot transfer the title into the LLC or into the trust, and therefore that asset will not be protected. Believe it or not, I've had clients who've forgotten that they owned some piece of property or some account somewhere, and that property never gets funded into the trust, and it doesn't get protected. So we really need to make sure we know about everything. We need copies of your deeds for both your home and any other outside real estate you might own. And we need to know who your life insurance, this is whole life, not term. So if it's term, we don't care about it. If it's whole life policy that has any kind of cash value, it becomes important. We need to be able to transfer ownership into the LLC or into the trust. We also want to know who your financial advisor is, if you have one, so that we can assist them in titling these accounts properly. Once we have drafted the documents, you need to review them, make sure we've spelled every name right. Our most typical spelling error is some strangely spelled name, like my own. My name is Michael, and I spell it Mikel, but that's not typically what you would guess. So we need to make sure all the names are spelled correctly. Then we need to schedule the document signing. That's real simple. If you don't have any questions about the documents themselves, those can take 15 to 30 minutes tops. I've had some clients who want to go line by line and have me explain every single phrase in every single document. I always joke that I need to charge an extra fee, and those people are typically the engineers who want that. They're curious and they want to know what every word means in the document. Either way, I'm fine with it. You're paying us a flat fee, so you get all the time that you need to be comfortable and to completely understand everything we do. I've not yet started to charge any kind of a premium for engineers, although I joke with them all the time that I will. Next, once we've signed all the documents, and the trustee will need to sign some of the documents. They don't always have to come in with you, but they will have to have their signatures notarized. So you can take the signature pages, or if they live out of state, we can mail them, or they can print them off and then have them notarized and mail them back to us. The deeds will need to be recorded at the county clerk or at the county where the property is located. That's typically a $50 fee to record your deeds. And then we need to transfer all the accounts and assets into the name of the LLC or into the trust. To wrap this up, you have to make the 5-year look back. Now, if you don't, we can still deal with it, okay? There are probably 15 to 20% of my clients who, for some reason, don't make the 5-year look back. We can still protect the vast majority of your property in that scenario. But you're just not allowed. Don't go to the nursing home. You don't want to go to the nursing home anyway. Why would you want to do that? You're going to be much happier in an assisted living or in at home where most people want to be. So we prefer none of our clients ever go to the nursing home, but that's just not the reality, unfortunately. Now, to help accomplish that goal, please consider a life care plan. We are a life care planning law firm, and we have elder care coordinators on staff who can help you assess the level of care that you might need, help you find that care at a reasonable cost or as cheap as possible, and also coordinate it and make sure that you're actually receiving what you need. Maybe we keep you out of the nursing home altogether. Wouldn't that be nice? Well, thank you very much, and I hope this helps. If you have any questions, reach out to us. If I'd have prepared a little better, I'd have put our phone number on this presentation. But if you reach out to eldercarelegacy.com, you can find our phone number. That's eldercarelegacy, all one word, .com. Our phone number is 859-298-2150. Thanks so much, and have a great day.